Rivers State House of Assembly has frowned upon the presentation of the 2025 Appropriation Bill by Governor Siminalayi Fubara to the three-member assembly led by Victor Oko-Jumbo, loyal to him. This was the theme of the Tuesday's plenary, during which the House Judicial Committee, led by Deputy Speaker Dumle Maul, presented the Court of Appeal judgment, which affirmed the legitimacy of the House, as well as the speakership of Martin Amehule. The Deputy Speaker then criticized the governor for disobeying the judgment. Two other lawmakers also expressed their strong displeasure at the governor's action, with a member, Smart Adoki, suggesting the judgment be submitted to security agencies for action. In his remarks, the Speaker, Right Honorable Martin Chike Amehule, stated that in the recent Court of Appeal judgment, the appellants, including the governor, lost on all grounds of appeal, except on the withholding of federal allocation to the state. The Speaker averred that, regrettably, Governor Fubara now sees himself as one who is above the constitution of the country and the judgments of courts, adding that such recklessness is an invitation to self-help and anarchy. Recall that on Monday, Fubara presented the 2025 proposal of 1.1 trillion naira to the Victor Oko-Jumbo-led Assembly. Fubara had described the 2025 budget as a blueprint for consolidating the achievements of his administration in 2024 while charting a new course for sustainable development. Let me start with you, Barrister Jamala. What do you make? I
was thinking and really praying in my mind that you will start with Zinami.
But then that prayer was not answered. So
anyway, I didn't pray to God, so I was just wishing. But since you have brought it to my table, I will start it by saying I think the caption was erroneously done.
What caption is that?
The caption talks about assembly, Rivers Assembly. Now, that assembly, by that caption, is laying credence to giving credit to Amehule and co. as being members of Rivers Assembly.
So who are the members of the Rivers Assembly?
Members of Rivers Assembly are those the governor presented the budget to.
What does the appeal court judgment say?
Which of the appeal court judgment are you talking about?
What does the appeal court
Which of the judgment? There are three appeals so far.
There are two judgments given so far.
There are three appeals so far that the Court of Appeal have decided.
What was the appeal court judgment of October? I think October 10.
That is that of the one that emanated from Omotosha's case.
What was the appeal court judgment?
To the effect that Martins and Amehule's group are members of Rivers State House of Assembly. But let me give you the shocker.
So now,
let me give you a history.
Hold on. You go ahead. You took a swipe.
Yes, that is the point I'm still making. It is that swipe.
To that,
no, let me.
You're saying that it was erroneously done.
Yes, to my own mind.
To your own mind.
Yes, it was erroneously done.
When you say it's erroneously done, I will protect the integrity of Atlantic Television Network.
It is not about the integrity of
It
Atlantic.
was not erroneous. Hold on, Jamala.
I think you are getting it wrong.
It was not erroneously done.
Okay.
Until a higher court says otherwise.
Get my point. Get my school of thought first.
Having said that, yes, you can continue.
For me to say that, you ordinarily should have calmed down.
It's not about coming down.
Get my school of thought.
You took a swipe. I will protect the integrity of the company. And I've done that, so you can continue.
All right. I said so because the Omotosha's case predates their defection.
Okay.
And so the Omotosha gave that judgment as though there was never a defection.
Okay.
Because it was never presented to him that we have moved. And because we have moved, we still want to be, or we are still allowed to be members of Rivers State High Court. So the status post-defection has not been decided. And so that was the same reasoning the Court of Appeal looked into. But all these issues of Court of Appeal and Omotosha, all of them went into nothing from December 11th, 2023. When this set of men defected in line with their right, exercising their rights, as provided for under Section 109 sub 1G, and sub 2 of it, 109 sub 2 of it. They said they exercised that right. On the point that there was a defection, or there is or was a defection in the PDP, And so their defection was justified.
There was a defection in PDP or crisis in PDP?
There was a crisis in PDP, thank you. And so their defection was justified. And so if you get the understanding from this point, you know that the Omotosho's case and that of the Court of Appeal has nothing to do actions post-defection. It is actions pre-defection that these things emanated. When they perceive a division from the assembly, they ran to Omotosho to protect their seats or protect their name. That was what Omotosho did. That in a valid constituted 31-man assembly, a faction of 3 or 4 cannot have prominence over a 27 members. Now, after these pre-defection issues, let's move to the post. We have argued here severally that while some of the view that Section 109, Sub 1 is a self-executory, others are saying no, it is ambulatory in nature, that you cannot exercise it until a court of law pronounce so. Now, the exercise of that right is if I believe or if I'm of the view that 109 is self-executory, you go and execute it in court and prevent me from holding that view. And that is what is pending before Federal High Court 2 in Port Harcourt. In the 2 cases that are coming, one is coming up on January 25th for judgment. And so if that is the position, then the assembly properly constituted is that of Oko-Jumbo. I will take us to Section 102 of the Constitution. As some persons have made mention of Section 90 or 96 that talks about a quorum, and made mention of Section 11 that where the House fails to constitute a quorum, the National Assembly should take over the proceedings of that. And I've said no, it doesn't work in this circumstance. Now, valid members of the House is where quorum is reckoned from.
Who determines the valid member of the House at this point?
Who determines the valid is the members of the House who live in. That determines, and that has been done by Ehie before he resigned.
Was Ehie in suspension when he emerged as Speaker?
If you suspend me from my own father's house, if my father disowned me from, or suspend me from his own house, so upon his death, am I entitled to inherit my father's inheritance? Despite the fact that my father has disowned him.
Who declared in this instance the seats vacant?
Have you forgotten a decision of court, which up to today has not been vacated?
A decision of court which up until date has
which
not
up
been
to today has not been vacated.
Did you also remember?
Because the parties,
did you also remember the judgment the order of Justice Wale and what the court said after that?
That is for Justice Wale. Have you talked about the other judge that came before Justice Wale's order? Because the parties in that matter are pro-SIM members and none of them has been appealed. Have you talked about that? And it was so glaring, it was so clear that the Commission of Information even have to revive our memory. We have all lost touch of that particular case. That was before my Lord, Honorable Justice Aprioku.
Which of the cases exactly? The
case that asks that these particular members should continue to sit and they should not be tampered with by anybody before Wale reinstated it. Has anybody appealed?
Justice Aprioku of State High Court.
Yes, River State High Court.
Go ahead.
It is that of Justice Wale that have been set aside by the Court of Appeal because the parties there came in and also appealed.
Between the judgment of Justice Omotosho and Justice Aprioku, which one took preeminence?
They are not of the same issues.
They are not of the same.
They are not of the same issues.
Are they legislative?
They are not of the same. They are not of the same issues. They are not of the same parties. Parties are different. Issues for determination are different.
Differentiate them.
While I said the first one, Omotosho's case, has to do with recognition of these persons prior their defection. All other cases has to do post-defection.
What was Aprioku's judgment? What was the prayer?
It was not a judgment. It was just an interlocutory order.
Interlocutory.
Yes,
what was the
it
prayer?
Was not a judgment.
What was the prayer?
To allow this set of persons to continue to sit unhindered, the Jumbo and Co.
Who are the set of the Jumbo and
Co? Yes, unhindered.
Right. Okay, so now if I understand what you're saying,
have you appealed against that order?
If I understand what you're saying,
yes,
these both cases have to do with River State House of Assembly.
Yes,
correct. And the Federal High Court in January 20th, 2024, by Justice Omotosho, gave judgments affirming Matesami Hule as Speaker of Rivers State. Hold
Pre-defection.
Hold on.
Oh, pre-defection, please. Let's get it right first.
Hold on, Jamala. Hold on. Pre or post, there was a judgment. The pre-defection and post-defection is what you argue out in court.
Yes.
What I am...
It's what we are even arguing here, not in court. That will build up our knowledge of our argument.
What I am looking at is conflicting judgment
over
the same legislative
house.
No,
they are not.
Hold on, Jamala. Now, Justice Omotosho's judgment affirmed Martin Samuel as the Speaker of Rivers State House of Assembly, and that came January 20th, 2024. And Justice Appropriations of the State High Court, what month was that order given?
I cannot recollect.
You cannot recollect.
Yes.
But then, that order, not judgment, that order came after Justice Omotosho gave his judgment. And that order was over the same legislative house. Now, regardless of whether the parties were different or not, there are conflicting judgments over an interest. Subject matter.
Issues of law.
Was it over the same subject matter?
It was not the same subject matter. That's what
Is it not the Rivers State House?
No, that the building, Chairman, wait, issues of law doesn't operate like that.
So now, a federal high court upholds one.
Can I come into what you have raised?
The federal high court affirms one as a speaker of Rivers State House of Assembly. Another state high court now says this one is the speaker of what exactly? Rivers State House of Assembly. It is one Rivers State House of Assembly here and not two. And now, going by the judgment of Justice Appropriations that the order of Justice Appropriations that you have brought up, that you said came before that of Justice Wale, we now have a faction, or we have two factions of the same house. We'll still come back to what you've said, but at this point,
I will. Sorry. So that my memory will not. Okay, go ahead. Will not fade up. Please. Issues of law. There's what we call cause of action in law. Before you institute an action in court, something must have happened to the fact that you are not satisfied with. So the cause of action in these two scenarios, these two cases, were never the same. That is the point I'm trying to make. My Chama, please. Can you please listen? That the fact that you took Jamala to court for the shape of his head will not stop another person from taking Jamala to court for the shape of his hand. But everything revolves around Jamala. That is the point you are trying to bring. And because someone took him to court for the shape of his head, another person taking him to court for the shape of his hand, it means there are conflicting on the same parties. No, it is not so. That is not how law operates. Issues that will arise from the shape of his head will be treated differently from that will come out from the shape of his hand. That is exactly what is transpiring in the Rivers State House of Assembly. And I said, remember, there are two different issues. One has to predate their defection. The others postdate their defection. And so you cannot lump all of them together to say they are one single issue and therefore they are conflicting. They are not.
All right, very well. I don't want to push for that because I need Jamala to speak.
You need Zinami.
Zinami. When Zinami is done, I'll still come back to you, Jamala.
That's why we're here.
Don't interject. Don't interrupt Zinami. I hope you won't do that.
Why are you preempting me? I never said.
I know you. Zinami, what do you make of this story?
You know, sometimes discussing these issues will make you turn to what I call it just skipped my mind, you know. But again, when we discuss issues of Rivers State, we are always sounding the same every day. Because the issues are not different. There is no the issue between the issue in Rivers State is an issue of who is going to lead the assembly. That is the major issue here. And so, for me, first of all, I don't even understand this press statement from the Amewule-led assembly, which has been recognized up to the Court of Appeal as a legitimate, legal, and lawful house. You know, because there's nothing to condemn.
When you say that,
no, there's nothing to condemn because for me, what does not exist does not exist. You can carry out an action, but if you are playing by the rules, it doesn't exist. It doesn't exist in the sense that they are not supposed to have seen that in the first place because What are you condemning when you know that thing is not existing? The court have said what is existing is Amewule as the speaker, and that house is the legitimate house. Whatever another person is doing does not exist. So what are you condemning?
Okay. If I understand you, you're
what are you frowning at?
In the first instance, Amewule shouldn't have
exactly. Don't even exactly.
Oh, okay.
If I was to advise them, that's what I would have told them. There's no point there, because these things have been recognized by the law. The Court of Appeal in this instance, from all cases, whether it's coming from CNYLO, coming from Motor Show, these courts have confirmed that Amewule is the speaker. And also, in Rivers State, like I've always said in the previous period that I appeared on this program, is that what is happening in Rivers State is a theater of the absorbed. If you go back to our previous discussions. Now, what is happening is that we are having the government of one man. And from all precedents, the governor is not ready to listen to any decision that does not go in tandem with his wish and caprices. And so therefore, whatever the court says, even if the Supreme Court speaks today, I can tell you here that it will be the 10th wonder of the world if the governor will listen. It will be the 10th wonder of the world if the governor will listen. And so therefore, we do not need to be, going back and forth, repeating the same thing, trying to confuse ourselves, convince us, trying to bring up issues that have been dealt with. So I don't even want to go into the legalities of all. All I know is that at the moment we speak, from the various decisions of the Court of Appeal, Amewule have been recognized in two occasions, even on the 13th of December. Just last month, 13th of December, there was a decision.
Yes. I have the CTC copy of
that was a decision. Although I have not been opportune to read the full judgment.
I will bring up the CTC copy on the screen, you would see.
You see? No, so I just said it now. So when we look at all these things, and so we are saying that we are presenting a budget. You are not presenting a budget. You are running a government of one man. One man of the guys said, okay, since you people don't want to agree with me, I'm going to do the way I want. And that's what is happening in Rivers State. So you cannot tell me that Oko-Jumbo is this, Oko-Jumbo is nowhere to be found. As far as the law is concerned, as far as the decisions of the court have been are something to go by. So we do not, I do not believe in these statements from Amewule saying this, saying that, and all that.
Now, Zinami is talking about post-election and pre-election.
Oh, Jamala.
And Jamala is basing his argument that because this was a pre-defection, a pre-defection case, according to him,
Shoma,
it means that appeal court judgment in this instance.
No, Shoma, let me refresh your mind. That's why I said I feel like it is a big burden to go back to discuss all these things.
But we have to, because we have to educate.
Because yeah, of course, that's correct. When you say post and pre, it's it's funny because first, we have said that Oko-Jumbo, in all his arguments in court and even in the decisions of the court, in the Court of Appeal in this instance, rose to proclaim himself the Speaker of the House by virtue of the declaration of seats vacant by Edison Ehie. These are the foundations of the issues. Edison Ehie was the one that purportedly declared these people's seats vacant.
He's saying that injunction was not
validated. No, it has been invalidated because all the actions of Edison Ehie was declared null and void. It was challenged. I don't know have the particulars of every decision. I will have laid it here, but I felt that these are things that we already know, and so I'm taking it for granted. But that is the situation. It was Edison Ehie who started the declaration, and that was when he made himself speaker and declared himself vacant, but they've defected. So if Edison Ehie declared themselves vacant because they've defected, is it not post-defection? I'm asking you, is it not post-defection? That's post-defection. That's post-defection. So having declared themselves vacant and Oko-Jumbo now rose in by virtue of Edison Ehie's another purported resignation from the house, and the court has said, Oko-Jumbo, you do not exist anywhere. So what are we not saying?
All right. I would have the MCR department put up the CTC copy of the judgment on 13th of December so that everybody can see the CTC copy and what the judgment says. Now it says in the Court of Appeal in the Abuja Division holding at Abuja on Friday the 13th day of December 2024 before their lordships, the name is mentioned there, and it says that between the government of Rivers State as appellants and Rivers State House of Assembly, the Right Honorable Martin Chike Amehule, Honorable Speaker, Rivers State House of Assembly, the Central Bank of Nigeria, Zenith Bank, Access Bank, Accountant General of the Federation, the Governor of Rivers State, Siminalayi Fubara, the Accountant General of Rivers State, Rivers State Independent Electoral Commission, Honorable Justice S.C. Amade, the Chief Judge of Rivers State, Honorable Justice Adolphus Enebeli, and these are the respondents. That's about 11 respondents. And they said judgment delivered by Hama Akawu Baraka JCA. Now, on to the second page. I will start from the second page where it says this decision. Please bring up the second page where it says the first sentence there starts with the worrisome aspect of the appellant's conduct. So I will read from the second paragraph. It says this decision being a judgment of a court of coordinate jurisdiction is binding on this court to the extent that the facts which it pronounces decision upon, which is on the validity and legality of the presentation of the Appropriation Bill by the Governor of Rivers State to 4 members of the Rivers State Assembly and affirmed the judgment of the trial court therein which had ordered that the governor should represent the said appropriation bill to the Rivers State House of Assembly led by the second respondent, hearing as the speaker. This judgment has pronounced on the issue of who is the speaker of the House of Assembly. It is binding on this court until the Supreme Court takes a final decision on the matter based on the appeal already lodged before it. It is wrong to say that since the particular issue is on appeal, it cannot be obeyed.
Exactly.
Let me repeat it again. It is wrong to say that since the particular issue is on appeal, it cannot be obeyed, since that judgment has not been stayed. Now,
on the whole, can you read the ending part of the judgment? On the whole, on the entirety of the judgment.
Islami, it would be nice if you don't interrupt. Thank you very much. Now, it continues to say again, as a matter of fact, it is the above judgment that gave an insight on the status of all the members of the Rivers State House of Assembly by stating that the second respondent, which is Martin Samehule, and his group are still members of the House of Assembly, since the High Court had no jurisdiction to make the orders barring them on the ground that their seats are vacant. The subsequent judgment of 10th October 2024 in Governor of Rivers State versus Rivers State House of Assembly and others is reinforcing this situation by declaring that the 7th respondent as governor cannot validly claim to have presented the appropriation bill of Rivers State to a House of Assembly of only 4 members, and that such presentation should be made to the House of Assembly led by the second respondent, which is Right Honorable Martins Amehule. The unambiguous effect of these 2 judgments of this honorable court is that as at today, the second respondent, which is Martin Samehule, and other members of Rivers State House of Assembly who allegedly defected are still legitimate members of the Rivers State House of Assembly and empowered to conduct the business of the House of Assembly. I abide by this well-reasoned decision of the court. My lords, it is meet at this stage to refer to section 281, subsection 1, subsection 2, and subsection 3 of the Constitution of the Federal Republic of Nigeria 1999 as amended, It states that the decisions of the Supreme Court shall be enforced in any part of the Federation by all authorities and persons and by courts with subordinate jurisdiction to that of the Supreme Court. The decisions of the Court of Appeal shall be enforced in any part of the Federation by all authorities and persons and by courts with subordinate jurisdiction to that of the Appeal Court. The decisions of the Federal High Court, a High Court, and all other courts established by this Constitution shall be enforced in any part of the Federation by all authorities and persons and by other courts of the law with subordinate jurisdiction to that of the Federal High Court, a High Court, and all those other courts, respectively. In the book of the Rule of Law and Disobedience of Court Orders in Nigeria, Adebayo Akinlade was disturbed and thereby quoted as having said, "Are we a nation where the rule of law is practiced or the rule of men is the norm?" Needless to say that the disobedience of court orders is detrimental to the rule of law, good governance, and progressive democracy, as stated. So, Sinami.
Yes, please.
What do you make of this?
This confirms what I've been saying since. Well, like I'm saying, I'm telling you that if you go to all the judgments, we are going to be speaking the same thing every now and then. You get my point? That is what I've said, and it's just the same thing that I've not read it, but I knew that there was a judgment because I was very busy this period. I've not been able to read, but I knew there was a judgment on the 13th of December. It was just that I was trying to read it, but it was not looking complete from the documents I have, so I decided to leave it. Well, I've not read it, but I knew that this is what will come up. You get, when we are saying that, what we are saying is this is what the court has said. It is spoken in simple and correct English. There is no Spanish, there is no Yoruba, there is no Ijaw, there is no whatever language that is there. It's for everyone to understand. Well stated, clearly spoken. You know, so we do not need to go here. Oh, let me tell you something. Let us face the fact here. Governor Sim is not ready to listen to the court. I've said it earlier and I'm saying it again. He will not listen to the court. As far as it is not in his favor, he will not listen. He will not obey. He's now running a government of one man. That is autocracy. Whatever he decides happen. So we do not need to start going to say what is happening is a sham. We know it. A 3-man assembly. Where does that happen? A purported speaker, purported leader, and a purported chief whip. Who again is there? It's 3-man now. It's 3-man.
I want to ask you a question from the constitutional angle right now, and not based on post-election and pre-election and all the judgments going on. What is the provision for presentation of appropriation bill? Is it 1/3 or 2/3? And then, if that is the case, I am aware that the Constitution says that the minimum seats in a House of Assembly should be 24, and the maximum 40. Now, if that is
Jamal, let us not go far. So I'm not cutting you short. Don't go too far. Don't touch to quote. We have 3-man. Victor. We have 3-man. Victor, my friend. It is not also constitutional now.
Was it aligned?
It is not. Even the Plateau State Governor, there's a case like that. It is not. They listen to the judgments that have been reeled out by the Court of Appeal in the various cases. You will see that the court continue to condemn a 3. The court is 4, but I'm thinking it's 4-man. My friend Victor, the IYC man that is now an assembly member, so correct, and the Opopo man, this other one, Adolphus. Who is there again? I think one other person. Is it Andoni also?
No.
That's it.
Man. It was 3-man.
It's 3-man. Is it 3-man? So what are we speaking?
I don't know where you're bringing all extra persons. It's 3-man.
It's 3-man. No, I want to even give them an extra person to see if maybe they've improved to 4. They cannot. It is not possible. It is not done anywhere. It is bizarre.
All right. Very well. Zinami, now what do you make of the appeal?
I don't know why you like calling.
I wanted to ask her if our name sounds familiar.
Sorry, Jamala.
Chama, when you were reading the Court of Appeal judgment, I asked you to go to what the court held. And you said I should not interrupt.
Yes,
I was thinking you were going to, on the summary of the judgment, what was the decision of the court, having analyzed all the issues. What does the court?
There were about 6 different issues.
I'm coming.
I can't read all.
No. There's a decision of courts ends somewhere. Either the appeal is allowed or the appeal finds merit is allowed. The appeal lacks merit and is hereby dismissed. Those are issues of law. My friends knows. So I mean, if you are selective in your reading, they will not be passing the message.
That was a consolidated judgment. How many judgments were read out on that? I am not about to read judgments on six matters.
It is not about.
I don't have the liberty.
Madam, with all due respect, will you please calm down? Let's look at these issues of law properly.
Go ahead.
You read out some issues of a judgment. With all due respect, that judgment was done. That matter was done by my office. And I have a certified true copy of that judgment in the office.
I can take a break so you bring it out.
Yes.
Should I go on a break?
If we go on a break, our time will be up, but you can come back.
I am patient.
I am talking about we have a certified true copy of the judgment in the office. And I am telling you what was the decision, final decision of the court.
Do you have the soft copy?
I don't have a soft copy, unless I will call our secretary.
Call your secretary to send. I will go on a break. Call your secretary to
please.
The soft copy.
When we discuss issues of law, you not. I will make. Let me continue. I know it is your program. Let me continue.
I want you to bring it.
I will bring it, madam. Let me finish my point. If you want to go on a break, you go on a break.
Don't worry. You will bring it in subsequent
program. The point I'm making is that issues of law are not reasoned randomly. It must be dealt with squarely in law. Yes, those pronouncements are contained in some pages of the decisions. But the Court of Appeal in this final analysis said the Federal High Court lacked jurisdiction and therefore struck out.
Lacked jurisdiction on what matter?
Lacked jurisdiction on the subject matter, which has to do with the presentation, with the River State budget. This decision you're reading is a flow from the decision of the budget presentation.
Jamala.
And therefore struck out the whole entire suit. Now, where a court lacks jurisdiction, any decision given therefrom ab initio is a nullity. But the court is allowed to say, peradventure we are wrong in holding that the court lacks jurisdiction. They now delve into the merit. But that is an obiter.
Jamala, do you still want to continue or can I say something?
If you want me to stop, I will stop.
No, okay, hold on. Jamala, now this matter that you're talking about, the judgment of December 13, is a consolidated judgment.
Consolidated judgment of which matters now? Which matters? That's not a consolidated. They are all appeals of the same sort. They are brought by different parties within the parties in the original.
Is it consolidated?
It's a consolidated, but the issues are the same.
Jamala, we are saying the same thing. Hold on. As much as you're a lawyer, I am extremely, hold on.
Yes.
As much as you're a lawyer, I am far from being unlearned as well.
I'm not saying now, but issues of law must be appreciated that way.
Is it consolidated? You said yes.
Yes,
so
consolidated.
Now, when I now said it's consolidated, why are you interrupting? Consolidated as in how?
I'm not saying.
Hold on. It was a consolidated matter. I am telling you.
Yes, I am aware.
Good. Now, hold on. When you say that the appeal court said that the Federal High Court did not have jurisdiction, the appeal court on that day handled 6 different cases that were on appeal. Jamala, hold on. Now, the one that was struck out, that the Federal High Court did not have the jurisdiction to entertain, was the issue of barring the Central Bank of Nigeria from paying FAC allocation to River State government.
I think at this point we can go on a break.
This matter, I will not go on a break.
No, at this point, I think we should go on a break. I want to bring the judgment of the court.
Jamala, hold on.
You said you should go on a break.
Jamala, hold on. I am the moderator.
I agree, but we must square it right.
I won't go on a break.
I cannot be bamboozled into towing a particular thought of direction. I will not do so.
You're not being bamboozled.
I will not do so. I will not tow that line. I will not.
However, I will also not let you turn a matter upside down.
I am not. I am giving you issues of law. No, that is the point.
You're giving
issues of law here. And I'm ready to, let's go on the break. Let me bring the judgment. Consolidated matters. What makes matters consolidated, Choma? is because the 6 appeals were revolving on the same issues.
There were 6 appeals, yes?
Yes, they were revolving on the same issues. And how were those appeals filed? Let me tell you, Choma. Rivers State Governor appealed. Accountant General of Rivers State appealed. Central Bank appealed. And one other party appealed. And so the issues of all these appeals are subject of the judgment of the Federal High Court that dealt with the stopping of allocation of funds. And they were brought together. They are brought together. Since the issues are the same, they were consolidated. And so a decision of one binds the other. That is the law I'm trying to make you understand.
Jamala, let me just say hypothetically, because technically, not even technically, I said one, it was a consolidated appeal. 2, there were 6 matters that were being treated in that appeal. And the one of the FAC allocation was the one that built around Rivers State High Court, the Federal High Court not having jurisdiction. Now, while I will not let you defer or deflect this conversation, let us go with the first appeal court judgment. And let's leave the one of 13th of December. Let's go to the one of 10th of December, because these appeal courts were saying the same thing. The question is, even in the one of October, I'm sure, the appeal court judgment says that Martin Samihule remains the Speaker of Rivers State House of Assembly. Now, whether it is post-election, pre-election, post-defection, pre-defection, mid-defection, up-defection, or down-defection, the thing is, there is a judgment by an appeal court. That judgment, and so far, as to the best of my knowledge, a higher court has not said otherwise. A higher court has not said otherwise. And now the governor has presented the budget to a 3-man faction of the Rivers State House of Assembly. And you, Jamala, you're saying that it is well within the right of the governor to do that. And you're saying that the 3-man faction of Rivers State House of Assembly, led by Oko-Jumbo, is the legitimate house. Is that what you're saying?
I am saying that insofar as the budget of 2024 that was presented to Oko-Jumbo has not been set aside by any court, there's nothing stopping the governor from presenting the 2025 budget, which he has done legitimately so to the Oko Assembly.
So there is no court that set aside the presentation?
There is no court that has set aside. There is no court that has set aside the budget of 2024. Not talking about the presentation. I'm talking about the budget itself that has been passed. Presentation is different. The process of passing is different. Assent is different. That law, the 2024 appropriation law of Rivers State has not been set aside by any court.
When the appeal court was giving their judgments, did they at any point say that everything done from the 2024 appropriation budget is illegal?
Not to my knowledge.
Did the appeal court say the governor should present the budget to...
You are talking about presentation. I'm talking about the law itself. I'm talking about the law itself.
Hold on. Now, talking about the law, the appeal court, when the appeal court even nullified the actions of everything that has happened in Oko-Jumbo and all that, did the appeal court nullify the actions of that house?
I'm not to my knowledge.
Not to your knowledge?
Yes.
Very well. Now let's look at constitutional provision. Can a 3-man assembly or a 3-man faction legislate for a state over an appropriation?
Is there a provision in the constitution that says what's the quorum? That's what I'm saying. I have, in my earlier presentation, I said quorum can only be reckoned with to valid membership of the house. That is.
What does the constitution say about the minimum seats of the house?
I cannot recollect.
24. I am surprised.
Minimum, I'm coming. Calm down. Don't mix up. Can you please listen? You asked me a question. Allow me answer. Minimum number of a house of assembly of a state. In other words, if the federation wants to create another state, the minimum standard of assembly member seat should be this number. What
was provided?
It's 24.
All right, very well.
It doesn't prevent an assembly less than... Go to section 102. Can you read section 102 of the Constitution?
What is the Supreme Court judgment?
Can you read section 102? So you browse it out. Section 102.
Jamala quoted.
Section 102 said nothing in this provision will prevent a House of Assembly from sitting if there is any vacancy in the seat. Or there are less in number in it. Go and read it, Section 102.
All right, very well.
So if you, I am saying quorum, Section 90. When we talk about quorum, talks about membership of the House. If a membership of the House is constituted of 24, what is 1/3 to form a quorum, and what is 2/3 to take some principled decisions?
Okay, very well.
So it's ascertained from there. So if the valid membership of the River State House of Assembly used to be 32, one died, we have 31, 27 by virtue of nature left their seats, and they were left with 4. Do you expect the state to be on standstill?
Okay, very well.
Answer the question. Do you expect the state to be on standstill?
Very beautifully put, Jamala. Now let us look at the Supreme Court judgment on Joshua Dariye.
I can't remember.
Well, that's what I'm saying, but I recall, Jamala, very, very well that you have quoted the Supreme Court judgment by Joshua Dariye on my show. I recall, that's why I asked you earlier. It appears that you tend to forget judgments and constitutions when it suits you. But then let me remind you.
If I have quoted Dariye's case.
Since you have forgotten, don't worry, let me remind you. In the matter of Joshua Dariye versus the, I think, Plateau State House of
Don't think, let's speak to facts.
Hold on, I know this. Hold on.
Don't think, just say the matter of Dariye versus.
Jamala, hold on. The matter went to court, and 8-member House of Assembly impeached the governor. And the matter went to court and up onto the Supreme Court. And Supreme Court, when giving judgment, said that these 8 House of Assembly members are legitimate House of Assembly members, and therefore they can legislate. However, in matters or legislations pertaining to 1/3 majority or 1/3 majority or 2/3 majority, if they do not form that quorum, they cannot legislate on that matter.
Can you repeat yourself again?
Hold on. That they cannot legislate on that matter. And based on that, the Supreme Court ruled that they overturned the impeachment of Joshua Dariye by an 8-man House of Assembly, based on the ground that they did not even form the quorum in the first instance to legislate over that matter. So since you have forgotten, I am now bamboozled and aghast that the Supreme Court can upturn the legislation or the action of an 8-man House of Assembly on the ground that they do not form a quorum. However, in the case of River State, it can be suspended and a 3-man can legislate over the appropriation bill of an entire 32 constituencies.
If you permit me to ask my learned friend, the two issues, are they the same? Issues as to quorum of impeachment of a governor and issues as to normal business of the legislation of the House, quorum of that House, are they the same?
Zinami, now, as a follow-up of that question, now,
because I asked him.
The impeachment of a governor, is it an exercise that falls within the jurisdiction of the legislative arm of a state?
Of course.
Now, appropriation bill, is this also an exercise approving the appropriation bill?
Of course.
It is also. So both of them are legislative exercises that falls within the jurisdiction of state houses of assembly.
That's correct.
And now,
however,
hold on,
let him mention the however now. No, Chama, you are limiting the scope of the discussion.
I am the moderator.
I agree, but you are limiting the scope of the discussion.
It is not in your place.
That is the general rule. Let him mention the exception to that general rule.
Zinami, let me ask you a clear question. The Constitution says that at every point in time, the minimum number of seats constituted for a legislative arm of a state will be 24. Now, and the highest will be 40. And Kano State is an example of the highest. Now, can a 3-man, now he's saying that the quorum, Jamala is saying that the quorum is according to the number of legitimate members in the House. I am not even looking at appeal court judgments now, affirming Martin Sameble as legitimate members of the House, but let us build on the hypothetical theory of Jamala.
No. We cannot build on his theory.
Okay, go ahead.
We cannot build on the theory because it is not the theory I agree with.
Okay.
Whether it's hypothetical or not, it's not the theory I agree with. So why would I build on his theory?
Go ahead.
You see, Chama, when you are doing the wrong thing, when you know that things are not properly being done, you will bring all sorts of arguments, all sorts of rules, all sorts of whatnot to justify your actions, and then even turn things upside down. I am telling you, there's a foundation has been laid. Are we here to build another foundation? A foundation has been laid by the Court of Appeal judgment. And even in the Court of Appeal judgment, they have said that 3-man committee, 3-man or 4-man committee cannot. The court have stated it. Who are we to come? Whatever the court stated was from the Constitution. Who are we to come and now start to saying that we want to build another foundation, build another theory? No. Whether legitimate or illegitimate, the court has spoken. Who made them illegitimate? The issue of legitimacy or not is in the Federal High Court, and he has stated that year that judgment will come up on the 25th of January in one of the matters.
So, when that judgment comes, the governor is bound to obey the judgment of...
The Court of Appeal judgment is subsisting or valid until it is set aside.
By a Supreme Court.
Yes, that is what we are saying
not
here. So no, yes, we don't need to we are over-laboring ourselves. We are over-laboring ourselves. What I'm telling you here, what the governor is doing is self-help, anarchy. He's doing it from his best pocket. Okay, Jamala is the person I want to go and see. I will go and see him and let him do what he wants me to do. Unfortunately for us, in Rivers State, it appears the chief judge is neither here nor there. Let me try to mind my words.
Why do you say that?
Because the chief judge is S.C. Amade. Simon Amade.
You say he's neither here nor there.
He's not looking like somebody that is ready to take up his decisions. He was in the party with Governor Victor Oko-Jumbo, and we had the governor and Fubara and other political parties in the state.
He's working with the governor. So
hold on, he's working with the governor. No, he's not whoever the governor is. He should be. He's the chief judge. He was here. He made the statement. Did you know the statement? Go and look for it. Go and look for it. You are the journalist. Go and look for the statement he made.
What in our discussion about defection?
No, we are talking about
judge.
No,
what in the defection? What in this theory? Let's see. You don't bring in a judge at the public.
I have the floor. I'm not castigating the judge. He made a statement.
That is not what we are discussing.
No, I am not casting aspersions. That
is not what we are discussing.
Whose horse is guard. I will do it. The chief judge made a statement. We are talking about judges here. So we're not talking about what do you mean?
What was the statement? Go ahead.
No, you are the journalist. Go and look for the statement he made at that Dr. Peter Otelé's
you are the one
party, Christmas party. I brought it up. I'm giving him.
You brought it up. You stated it.
No,
you brought it up.
You are not questioning me. Allow me to speak. Allow me to speak. When you spoke, I didn't question you. Allow me to speak. I have the floor.
Zenami, you have the floor. Go ahead.
Now I'm telling you now that what is happening in Rivers State is an issue where everything has been compromised. That even if even the chief judge appears to be compromised by virtue of the statements he made at Dr. Peter Otelé's birthday party or Christmas party, where political parties members were involved. What is the chief judge doing there when you're talking about issues of judgment and issues of impeachment and issues of who is the right assembly, who is not the right assembly, who is governing Rivers State well, who is not governing Rivers State well? A chief judge? What are we not speaking?
All right, very well. At this point, it appears that we are now at a bigger crossroad with 2024 budget still under litigation, and the presentation of the 2024 budget still under litigation, and the appeal courts insisting that the governor should present the 2024 budget to Martin Samuel, Rivers State House of Assembly, and the governor still going ahead to present the 2025 budget to Oko-Jumbo led faction. At this point, it appears that Rivers State is at a crossroad. Now, as we round up this segment of this show, Jamala, what is the way forward?
For me, there's no way forward. The way forward is for the House of Assembly to go ahead and pass the budget. That is all. There's no way forward.
So if I understand what you're saying, Jamala, as a lawyer, a practicing lawyer.
Very well.
And when I introduced you, I called it Esquire. So you're a practicing lawyer who is well versed with the law, and you pride yourself as a learned gentleman.
Yes.
You are saying that it is okay for the governor to be in contempt of court.
Do I have a right to say so? You are the one saying contempt of court. The court has not said so.
Now,
so please, I will not answer that. You have a court has. I have not. The court has not held the governor in contempt. Choma, if you want to ask me personal questions,
so now,
ask me personal questions.
What you're saying in essence is,
yes, don't. That's contempt.
What you're saying in essence is, it is okay for Governor Siminalayi Fubara to disobey the judgment of the appeal.
The court of appeal, and present Fubara has not disobeyed
to another faction.
Let me get you clearly. Fubara has not disobeyed the court of appeal. Fubara was never mandated to present 2025 budget.
2024.
I'm coming. What he just did is 2025.
Now,
Fubara was not mandated to present 2025 budget to a particular set of persons that you will say is in contempt of court.
All right, very well. Fair enough. Now, which House of Assembly did the appeal court affirm as the House of Assembly?
The Court of Appeal in the, what's his name, Motosho's case, affirmed Amewole. And I'm of the view and the school of thought personal to me, and I hold that right so gladly.
Okay.
And without any iota of doubt that ceases to become.
All right.
And if our views are justified, every other argument for the past 1 year that we have labored issue would die a natural death.
All right, very well.